Good morning. So we're on the record in docket 18-01945. That's TNT Financial Incorporated versus Ventitious Skipwith and DeCecil Skipwith. Will the parties please introduce themselves for the record?
Good morning, Your Honor. James Meineke appearing on behalf of the plaintiff TNT Financial Inc.
And sir, you are DeCecil Skipwith?
Yes, that's Cecil Skipwith.
All right. Yes. And you can hear me all right, Mr. Skipwith?
Yes.
All right. And is Vantisha Skipwith with you?
No.
All right. This is the time and place set for an objection to a motion that was filed in regards to installment payments. Mr. Meineke, how are we proceeding today?
Your Honor, I'd like to proceed with the motion. This motion is with respect to DeCecil Skipwith only. There is an order regarding installment payments for Mr. Skipwith that called for him to make payments of $100 a month beginning on June 15th, 2021. In each month after that, we had a hearing on this in April. TNT had agreed to allow him to resume his $100 a month payments. So we withdrew the motion, and he failed to make any of those payments after April, which required us to file this motion today. So we would ask that the court set aside the order for installment payments for $100 a month.
Mr. DeCecil, your response?
Yeah, we had agreed on the payments. I called to make the payments, and they refused to take the payments. Me and the attorney, we talked. Is supposed to give them the information, give them email address. I don't know if he refused to do so, but I called. I had a witness to Vantisha. She witnessed them. They refused to take the payments 3 different times, and I was stuck. Not to. I mean, what I'm supposed to do if somebody not supposed to take the payments? I called. Their clerks was like, we'll call you back. You're not in our system. We'll give you a call back. And I never heard back from them. So, I mean, what am I supposed to do?
So your testimony on the record is that you've not made any payments to the debt. You were behind $800 on the debt in June.
I'm not behind $800. That's something they just put down. We just met in June. We met in June. We had a meeting that they got $1,000. They got $1,000 from the taxes in June. We were supposed to move forward with $100 payments. They never accepted any payments. When we had our court date, I called. They said that we can't accept no payments. Like, so I'm like, what am I supposed to do? I called several times and they did that to me. Like,
so your testimony today, you're indicating to the court that the moving party has not accepted any payments.
Exactly. They told me
that was due to them.
Yes.
Mr. Meineke?
Yes, Your Honor. On the date of the hearing, April 8th, 2022, Mr. Skipwith called TNT Financial from a number we have in the system. He indicated he didn't want to make a payment without the person who was handling his account, her name is Heather, being here, said he would call back the following Monday. That was the last communication we had with Mr. Skipwith. He has not called. TNT Financial is not rejecting payments. They would take the $100 payments all along. So that's untrue, Judge.
That's not true. The lady said, "You're not in the system. I can't take payments." When I said, "When you want me to call back?" She's like, "Heather's not here." She was like, "I can't take your payments." I said, "When you call me back?" I was like, "When you want me to call back?"
How about this,
call back.
Mr. Skipwith? Mr. Meineke, I could set this for a control date, and we can see if Mr. Skipwith sends a payment that is accepted by you within a certain amount of time, and that would be the usual course of payment. Of course, I'm talking about a week in order to test Mr. Skipwith's theory that you won't take money that's owed to you, which I find surprising, quite frankly, that you would. I've never heard of such a thing, that somebody would not take money that was owed to them. But in order to test Mr. Skipwith's theory, I'm assuming he can make a payment in the next week.
Yes.
Is that true, Mr. Skipwith?
Yes.
All right. Well, then I'll hold my judgment on this case. I'll take it under advisement. Mr. Meineke, how would you like to be paid?
He can pay over the phone with a debit or credit card if we have a good email address for him. We can email him the receipt right away. If he wants, he could go to the Lansing office of Fast Finance Auto Sales and make a payment in cash and get a receipt right there on the spot. Either one of those options are fine.
Mr. Skipwith, those are three reasonable options.
That's not true. None of those are true. I have did all of
well, I know you're saying that. I
have did all of that.
Mr. Skipwith, you got to stop talking. All right, you got to stop talking. We've come up with three reasonable solutions for you to pay. Now, if you're going to pay today, okay, then you have three reasonable solutions. We'll put them on the record. And if that doesn't happen, well, then we have an understanding that maybe the motion to set aside the order should be granted because you're not making payments.
That'll be true. That'll be true.
So what is the first?
What happened? What will happen? You throw the case out if I can't make a payment in, right? If I get a recording,
if you don't make a payment within the next week, we're gonna come back here and Mr. Meineke is gonna get what he requests.
No, I'm saying on my behalf. If I get a recording, because I'm gonna record it. If they don't accept the payment over the phone, because you can't go in office, because there's no TNT, there's no financial here. It's just their card payment.
There is a brick and mortar building that you can make a payment.
A brick and mortar building. Okay.
There's an actual building that you can make a payment to. So I'm gonna set. So let's do this. Option one, Mr. Meineke. What is option one for the record for Mr. Skipwith?
If he wants, the option one, probably the safest and easiest way, he wants a brick and mortar. It's the Fast Finance Auto Sales building where the vehicle was purchased. There's a TNT financial office window there. He can make a payment there by, I believe, debit or credit or cash or check. If he has check, he can make all those options there and get a receipt in the spot. Option two is to call the 800 number, 800-822-6410 with a debit or credit card in his name. And then if you have a proper email address for him in the system, they would email him a receipt right there in the spot in addition to whatever he has with his debit or credit card statements. All right,
Mr. Skipwith, do you have an email address that you can be contacted at for the record?
Yes.
All right. What is that, sir?
It's Terry4915@yahoo.com.
So it's Terry. Do you have that, sir?
Yeah, we do have that, Judge, in the system for him. Yes.
All right. So, Mr. Skipwith, I'm going to take this motion under advisement till next week at 8:15. It'll be 8:30 next week. 8:30 next week, okay, which would be for the record. So I'm going to take it under advisement, and it'll be 8:19 at 8:30. I'm assuming that there are no objections to Zoom in this from yourself, Mr. Meineke?
No, Your Honor.
Any objection to holding it by Zoom, Mr. Skipwith?
No.
All right. So on August 19th at 8:30, there are various reasonable ways to make payment here, and I'm assuming the plaintiff wants their money, and we'll come back and address to see if the money's been paid. If it's not, then the court's going to have a little different view of this request. So we'll all be back here August 19th at 8:30. Anything else for the record, Mr. Meineke?
Nothing further this morning, Your Honor.
All right, thank you, sir. Anything else, Mr. Skipwith?
No.
All right, that's all for the record, docket 1801945. Thank you for your appearances and have a nice day.
Thank you.
So we're on the docket in case 1804332. That's Astera Credit Union versus Barry McDaniel and Mariah Lavenway. This is the time set for a motion today. And will the parties please introduce themselves for the record?
Your Honor, thank you. May it please the court, Stephen Bequicchio on behalf of plaintiff and Astera Credit Union.
And I want to make sure it's Bequicchio.
Bequicchio.
Bequicchio. Okay. And this is the time set for a motion in the matter. It is now 8:45. This case was set for 8:15. I don't see Mr. McDaniel or Ms. Lavenway in the Zoom courtroom. And I don't see him in the regular courtroom. Mr. Bequicchio, how would you like to proceed?
Thank you, Your Honor. I'd like to proceed with our motion.
You may.
Your Honor, this is a motion to correct clerical error on a satisfaction of judgment that inadvertently checked the all defendants box when it was only as to one defendant, Miss Mariah Lavenway. So we're seeking an order to correct that, have a satisfaction of judgment rightfully continue as to Mariah Lavenway and reinstated judgment or rescinded as to Barry McDaniel, who is the co-defendant in this matter.
All right, so the request is to rescind as to Barry McDaniel. Is that correct?
Yes, Your Honor.
And then to continue as to Mariah Lavenway.
Yes, sir.
And that motion is granted.
May I approach?
You
Your
may.
Honor?
I'll sign an order to that effect.
Sorry, Your Honor.
That's fine.
Sure tired. And my first time in front of you, honored to be in front of you.
Thank you.
Thank you. Should I bring this to the clerk's office?
Yeah, take it to the civil clerk's office and they'll take care of it for you.
Thank you.
Anything else for the record in 1844332?
None, Your Honor.
Thank you, sir. Have a nice day. All right. So we're on the record on your case, Ms. James. Docket 22015553. That's People of the State of Michigan versus Quody A. McInnes. Let's see if I need to correct that. This is the time set for a probable cause conference. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of Cody McInnes.
And sir, you are Quody McInnes?
Yes, sir.
All right. You can hear me all right, Mr. McInnes?
Yes, sir.
All right. This is the time set for a probable cause conference. Mr. Westy, how we proceed?
Your Honor, I haven't had an opportunity to discuss this case with Ms. James yet. I would request a breakout room if she would agree to that, just go over some things before.
Ms. James, would you be amenable to a breakout room with the assistant prosecutor concerning this matter?
Yes, absolutely.
All right, then I'll wait for Mr. Westy to get in the Zoom room. I believe he'll do it by laptop, and then I'll put both of you in a breakout room. All right, Ms. James?
Thank you.
Thank you. Mr. Williams, you're here on Jessica Krawczyk.
That's correct, Your Honor.
All right, and is she with us today?
Your Honor, I need to ask for an adjournment. She had a bad accident yesterday, automobile accident. Her son had a punctured lung. We've been trying to reach her to find out what her condition is, but she was aware of the fact she was supposed to be here at 8:30 this morning. So but I don't know what her medical condition is because of the accident.
Well, I think let's get the assistant prosecutor here after he gets out of the breakout room. I have no problem with leaving this, at least leaving it for prelim for 1 week, so the 19th, just to see the status of your client and see if she's, seriously injured. I do know, just between before we go on the record in the case, once the assistant prosecutor gets here, that we don't have an appearance for you in the file. So you want to make sure that paperwork gets to the file on your client's behalf.
We did send in an appearance, Judge, but I'll make sure you get another copy.
All right, and just in case, because we have different emails available, you can send your appearance to Judge Flores courtroom at lansingmi.gov. Because I understand there are multiple emails that are involved.
Okay, will do, Judge.
All right, so stand by and we'll wait for the assistant prosecutor to get out of the breakout.
Yeah, he sent me an email with an offer, but the problem is I can't, with her being unable to come in, I don't know whether she would accept it or not.
All right, fair enough. All right. That was a fast meeting. All right. So we're on the record in docket 22015553. Mr. Westy, you've had the opportunity to speak with Ms. James in a breakout room?
Yes, Your Honor.
All right. And how are we proceeding today?
Ms. James and her client would like to waive the 21 days as she was just retained. The people would also waive their right to have it within 21 days.
And then is there a request to adjourn it outside of next week's date?
I would defer to
All right.
the defense counsel.
All right, Ms. James, my understanding is today your client is willing to waive the right to a 21-day prelim within 21 days of arraignment. And is just for calendar purposes, will you be requesting a date outside of next week's August 19th date?
We will, Your Honor. We were just retained yesterday. We don't have any discovery yet to allow us to receive discovery and go through everything. Additionally, there will be a conflict. We have an exam and a couple of motions next week on the same day. So we will be requesting an adjournment on the exam.
All right, so may I inquire of your client of his waiver of the 21-day rule?
Yes, you may, Your Honor.
So Mr. McInnes, Mr. Cody McInnes, you understand that you have the right to a preliminary examination within 21 days of arraignment. Do you understand that, sir?
Yes, sir.
And a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. Do you understand that?
Yes.
And of course, you're represented by Ms. James, and you'd be able to contest any charges brought against you and cross-examine any witnesses brought against you in that hearing by your attorney, Ms. James. Do you understand that?
Yes. Yes, sir.
It's my understanding that because you've just retained Ms. James, you're requesting that we adjourn the prelim set for August 19th, and that you are waiving your right to a prelim within 21 days, but you're not waiving your right to have a prelim. You're only waiving your right to have it outside of that 21-day period. Is that correct, sir?
Yes, sir.
All right, so I find that the waiver of the 21-day rule to be knowing, understandingly, and accurately made. We will adjourn, and it's my understanding from your counsel, we're adjourning it outside of August 19th. So we'll get a new date.
September 2nd.
So it'll be September 2nd at 8:30. Will that be sufficient time for discovery purposes from the people?
Yes, Your Honor.
From Ms. James?
Yes, that works, Your Honor. Thank you.
All right. Anything else for the record in docket 22-01553, Mr. Wisty?
No, Your Honor.
Ms. James?
No, Your Honor. Thank you.
All right. That's all for the record in the file. And then Mr. Wisty, we have Ms. Krawczyk. Mr. Williams is here on Ms. Krawczyk, who has been in a car accident. And that's the indication from the attorney for non-appearance. So my inclination is to leave it on for prelim at this time and until we find out the status of the defendant. Is that fair? So let's put that on the record. We'll put it all on the record. So we're on the record in docket 22-01906, People of the State of Michigan versus Jessica M. Krawczyk. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
David Williams on behalf of the defendant. Judge, just to reiterate what I indicated earlier, she was in my office yesterday morning. She was aware of the hearing this morning, but she was on her way with her son and they were involved in an automobile accident. Her son had a punctured lung, was taken to the hospital. We tried to reach her yesterday afternoon to find out her status. We were unable to reach her and she didn't show up this morning. So I'm thinking that she's probably being treated for her injuries too.
All right. Yeah, there seems to be a reason why the defendant's not here for the probable cause conference. So, and it seems to be valid. However, and I've told Mr. Williams that, and given him an email that we'll need an appearance for the appearance. He's here on the record, but he's going to submit an appearance. Hasn't made its way to the file. It would be the court's inclination at this time to leave it on for prelim on August 19th to see what the status of the defendant is. And then in the interim, Mr. Williams and yourself can speak.
That makes sense to me, Your Honor.
Mr. Williams, does that make sense?
Yes, it is. He did send me an email. I was going to take it up with my client if she did make it in this morning, but I haven't had a chance to talk with her about the offer.
All right. So I'm going to leave on for preliminary examination for August 19th at 8:30. And also just to make sure that the defendant is, is in a condition that we're able to have a prelim, and then we'll readdress this next week. So just, Mr. Williams, keep in contact with Mr. Westy, and just so we know the condition of your client, okay?
As soon as we find out, I'll let him know.
Perfect. Thank you, Mr. Williams. Anything else for the record? Docket 22-01906, Mr. Westy?
No, Your Honor, and then Mr. Williams, just I would obviously have no problem adjourning the prelim if that's an issue, and I hope she's doing okay.
Fine, thank you. We'll keep you appraised.
All right. Thank you, Mr. Williams.
Thank you.
That's all for the record. Much quicker than